When a family brings a wrongful death claim, they will eventually have to ask a question that feels impossible to answer. How do you put a number on a human life? Now, what an unseemly question, right? It can feel wrong to even think about it. But in our civil justice system, that's exactly what we have to do. And that's because it's the only tool the system has to provide for a family's future when a family member has been taken from them. It's not about replacing a life. It's about providing a measure of justice so a family can move forward. My name is Kevin Jones. For over 15 years, I've helped families navigate this difficult but necessary process. Today, I'm going to show you how we value wrongful death cases here in Missouri. We're going to talk about the 3 key factors that determine what is fair and just under the law. And these 3 factors are best understood as 3 distinct stories that are embedded into every wrongful death case. And these aren't stories in the fictional sense. They're narratives constructed from facts and evidence. And as we prove each story, we build the case's value layer by layer until we create a complete picture of what justice requires. Let's begin with what is often the most straightforward part of the valuation, the story of the economic loss. And this is really the math part of the case. It's about calculating the financial losses to the family unit. Let's start with the case of a wage earner. To prove this loss, it's not enough to just show a pay stub. We have to hire an economist to calculate the full value of the lost income, benefits, and retirement over a lifetime. Let's take an example. Say we represent the family of a 45-year-old union electrician. He had a long work history. We don't just show to a jury his last pay stub. We give the economist his tax returns for the last 10 years, his union contract detailing every scheduled pay raise, his W-2s showing how much overtime he was working, and the statements for his 401k and pension fund. The economist then projects that out over the next 20 years of his expected work-life expectancy. They calculate the lost salary, the lost overtime, the lost health insurance benefits the family now has to pay for, and the full value of the pension that is now gone. Suddenly, a $70,000 a year job is shown to be a $2 million economic loss for the family. And that's not an emotional plea, it's just math. But what happens when the person who died wasn't a traditional wage earner? What about a child or a stay-at-home parent? Well, their loss also has tremendous economic value even though they weren't bringing in a traditional income. And Missouri law provides a specific way to calculate their economic loss using what we call rebuttable presumptions. A rebuttable presumption is just a legal starting point. The law presumes a certain value, and then both sides have the chance to present evidence to argue that the real value is either higher or lower. Let's look at the death of a minor child. The law presumes that the annual economic loss is to be calculated based on the parent's annual income. So if a child's parents have a combined income of $100,000, the law presumes an annual loss of that amount. Now, the plaintiff's expert in the case can then project that value over the parent's life expectancy, which can result in a multi-million-dollar figure. Now, because this is a rebuttable presumption, both sides can challenge it. We, on behalf of the family, we could present evidence to argue that the value should be higher. For example, what if the child was a high school senior who had already won state awards for coding and had a full scholarship to a top engineering university? The evidence might show that they were on a different career and financial trajectory, perhaps one that their parents never had the opportunity to pursue. We would hire a vocational expert to prove that their earning potential was far greater than their parents. And the defense might argue that the value should be lower. They'll say that the child would have consumed most of their income, or that the parent's average income was skewed by a one-off high-earning year. And the jury gets to hear both sides and decide what is fair. The same principle applies to the death of a caregiver or a homemaker. The law presumes the value of their services is equal to 110% of the state's average weekly wage. Again, this is just a starting point. The defense may try to argue this number is too high. For instance, they may hire their own expert to testify that the market rate for cleaning or cooking in that specific town is lower than the state average. Or they may present evidence that the person being cared for, if it was an elderly or disabled person had a limited life expectancy according to their age and health, so the value shouldn't be projected for decades. But we can rebut the presumption with our own evidence. Sometimes we hire experts to show the real replacement cost of all the services a caregiver provides. The cost of a nanny, a cook, a cleaner, a tutor, a chauffeur is actually much higher than the presumed amount. The point is that even when a loved one wasn't earning a paycheck, their loss creates a real economic void. The law provides the framework for the calculation, and it's our job to use evidence to tell the economic story completely and accurately. But the economic story, as important as it is not the heart of the case. Now we have to talk about the story of the human losses. And this is what the law calls non-economic damages, and it's truly the heart of the case. This is where we have to value human losses, and that's a hard thing to do. Missouri's wrongful death statute specifically allows a family member to be compensated for the loss of companionship, comfort, instruction, guidance, counsel, training, and support. Now, the law is very clear that the jury cannot award money for a family's grief and bereavement, and this can feel cold and confusing, but the law is trying to compensate for the loss of the relationship itself, not the emotional reaction to the loss. But here's the reality, though. The deeper the relationship, the more profound the loss. The evidence that we use to prove the value of the lost companionship, guidance, and support will naturally also show the depth of the family's grief, so they go hand in hand. We focus on proving the value of what was taken from the family, and that value is what the law allows compensation for. So let's look at what the law allows compensation for. It's not a vague catch-all term like pain and suffering. The statute identifies specific, provable losses. First, there's the loss of companionship, and this isn't just about living in the same house. It's about the shared life, the value of not being alone. We might prove this with testimony from the deceased best friend who will describe what those weekly fishing trips with the father meant to the son, and how that loss of that special time together has left a void in the son's life, or with photos from the annual family vacation that was the highlight of the children's year. We tell the story of the inside jokes, the shared hobbies, the quiet moments on the porch. That is the companionship that was lost. Next, we have loss of guidance, counsel, and instruction, and this is especially powerful when a child loses a parent. We might bring in the child's teacher, who might testify about how the mother volunteered in the classroom and helped her child learn to read. We might show the emails that the father sent to his daughter in college, giving her advice on her classes and her career. We might have a grown son testify about how his father taught him to be a good husband and a good father himself. This is the loss of a mentor, a teacher, and a role model. Finally, there's the loss of comfort and support. And this is about the loss of that one person who was your rock. We might have a spouse testify about how their wife was the one who calmed their fears, who took care of them when they were sick, and who could always be counted on. Or we might have an adult daughter testify that her mother was the one she called every day on her commute home from work, the one person she could vent to, who would always listen without judgment. That daily ritual of comfort is now gone forever. And we prove this with things as simple as a saved email, a thinking of you text, or a birthday card with a heartfelt message that shows how much they cared. By building this mosaic of a person's life through testimony from many people and tangible evidence, we can make the human loss real and undeniable for a jury. We tell the story of the specific, unique person who was gone and the enormous void they left behind. The first two stories establish the scale of the family's loss. The third story, what happened and why, is the most critical because it determines who is responsible. And proving that the defendant is liable is the key that unlocks any compensation for the family's losses. Without liability, the value of the losses is effectively zero under the law. And the story of what happened and why has essentially two parts: proving the defendant's liability and then analyzing the risks and possible outcomes of a trial. First, we investigate to find out what happened. We get the police reports, we interview witnesses, we subpoena company records, we hire accident reconstructionists, we get the deceased medical records, and sometimes we even have to arrange for a private autopsy if the cause of death isn't clear. And once we have all the information, then we need to analyze the risks of losing or obtaining a reduced award. In the states where I practice, juries can assign a percentage of fault to all parties involved, including the person who died. This is called comparative fault. If a jury finds the deceased was 20% at fault, for example, any award is automatically reduced by 20%. So when we value a case for settlement, we don't just add up the economic and human losses. We have to be brutally honest about our chances at trial. And there are different ways to approach this. Some lawyers rely on gut feelings. Some take an ego-driven approach and just ignore the risks. But we believe in giving our clients a rational basis to make an informed decision during an incredibly emotional time. It's not required, but one method we use is to calculate the expected value of a case. It's a data-driven approach. In statistics, the expected value is the predicted value of a variable, calculated as the sum of all the possible values, each multiplied by the probability of its occurrence. In plain English, it's like averaging the results of the case if it were tried hundreds of times. It lets us factor in both the size of the potential award and the chances of winning it. So to calculate the expected value of a case, we first determine a range of what we believe a jury is most likely to award for the family's total losses. And this is based on historical jury verdicts in similar cases in that venue, but we also factor in the defendant's conduct. If we can prove aggravating circumstances, which is Missouri's version of punitive damages for wrongful death cases, it means that the defendant showed a complete indifference to the safety of others. Think of a trucking company that forces its drivers to work past legal limits. And proving this can dramatically increase the top end of the potential award range. Once we have that likely range, we take the midpoint as sort of a starting value. And then we honestly assess the risks. And we'll look at the historical data of what juries typically do in that venue with similar cases, how often they return verdicts for a plaintiff or defendant. But this is also where an attorney's experience and judgment are critical. We analyze the specific facts of your case, the strengths and weaknesses of the evidence, the credibility of the witnesses, because these are unique factors that can make historical averages misleading. And we adjust our risk assessment based on these fact-specific details to get a realistic view of the possible outcomes. Let me give you a basic example. Let's say that we determine a likely jury award would be around $2 million, but we think there's a 10% chance a jury finds for the defense, meaning that we would get zero. We also think the jury will likely find the deceased 25% at fault. Well, first we discount the likely award by the comparative fault. 25% of the $2 million is $500,000. So the likely net award from a jury is $1.5 million. But we still have that 10% risk of losing altogether. So we'll discount the $1.5 million net award by that 10% risk. And that gives us a final expected value of $1,350,000. Now, it's important to understand a key limitation of this method. The expected value is a statistical average. It tells you the average outcome would be if we were to try the case 100 times. But you only get one shot, and there's no guarantee about what a jury might do with the case. And this is why a family's personal comfort with risk is so important. A more risk-averse family might be happy to accept a guaranteed settlement that's a bit lower than the expected value to avoid the chance of walking away with nothing. Another family might be willing to take the risk, maybe because they put such a high value on getting to tell their story in a courtroom. The expected value isn't the final word. It's a tool. It's a rational data point that helps a family understand the risks and the range of outcomes so they can make an informed decision that's right for them rather than one based purely on emotion and guesswork. The main point is this. When you think about what a wrongful death case is worth, there's not a set number for all cases. It's a combination of three stories: the economic story, the human story, and the story of what happened and why. And putting all these pieces together, the economic analysis, the human story, the facts of what happened, is how we build a case that truly reflects the measure of your family's loss. It's about moving from uncertainty to a clear evidence-based understanding of your case. assets. This knowledge is what empowers you to make the best decisions for your family's future. Now, I know this is a lot of information and it can be overwhelming to think about during such a difficult time, but my hope is that by understanding how this process really works, you feel a little more empowered. The goal isn't to rush into a lawsuit. The goal is to arm yourself with knowledge so you understand what is necessary to protect your family's future and honor the memory of the person you lost. The first step is simply a conversation to get clarity on your situation. If you're ready to have that conversation, we're here to listen. You can call my office or use the link in the description below to book a free confidential conversation. I hope this video was helpful. Thank you for trusting me with your time.